TRADOC, PAM 604, 604, Chapter 3, Standard of Conduct, Initial Entry Training, Military Handbook. 3.1. The Uniform Code Military Justice UCMJ, the military standard discipline is founded by the self-discipline, respect the authority, embraces the professional army ethic within supporting individual values. Military discipline is developed in the individual group in training to create a mental attitude that will result in proper conduct, proper obedience to the law or military authority. These are three basics. Don't break the rules. What are the rules? Except accurately U.S. Code of Military Justice regulations. Take responsibility for your actions. Keep your hands yourself. When the military discipline is a result, effective training is effective. It affects every aspect of the military life. It is if a traitor is found in individual units or manifested unit cohesion, bonding spirit of teamwork, manifested by unit cohesion, bonding spirit of the teamwork, smartness of appearance and action, cleanliness, maintenance, dress, equipment in his quarters, respect to the senior, mutual respects between their senior and subordinate personnel, prompting willing execution of the both, the letter, the spirit of the legal orders, the lawful commands, fair justice, equity of the soldiers, regardless of the race, religion, color, or the regard of national origin. U.S. Code of Military Justice applies to active duty soldier 24 hours a day, 7 days a week, anywhere you are in the world. After discharge, if discharge was fraudulent, was obtained fraudulently, and active duty status terminated for the reserve and national guards. In other words, if your duty is to abide by the law or regulations governed by the U.S. Code of Military Justice 24 hours a day, 7 days a week for as long as you are in the Army, all personnel in military services are required strictly to obey and promptly execute the legal orders and lawful regulations as part of the everyday life. The U.S. Code of Military Justice gives a judicial with essential Army ability accomplishing military mission. The U.S. Code of Military Justice is the statute that prescribed criminal laws of soldier. The U.S. Code of Military Justice authorizes non-judicial punishment, commanders, judicial punishment, and court-martial military courts, and it also provides punishment in the strictly military offenses. Military offenses are not common in civil law. Examples include the failure to repair, absent without leave, disrespect the non-commissioned officers, other commissioned officers, disobedience of their orders. If the principle of accused innocent until proven guilty applies for the non-judicial punishment and court-martials, you have the right to be informed of any charges against you, as well as the names of accusers as known witnesses. You also have the right to remain silent if you do not have anything to say. Could be anything you say can't. You don't have to say anything that could be used to convict you. Anything you can be used as evidence against you. The right of the military lawyer, unless you wish to hear a civilian lawyer at your own expense. Hire a civilian lawyer at your own expense. Protection against double jeopardy. If you found innocent in the court-martial, you cannot be tried again by the court-martial for the same crime. The right of sentence review. The higher authority automatically reviews the confliction of the received in the military. The sentence cannot be increased, may be the left and decrease. The right to speedy public trial. The right to call the witness favor to you. The rightness to interpret if you do not fully understand the English language. The right of the enlisted person to have at least 1/3 of the enlisted court members. The right to be tried by a military judge other than by a court martial panel, unless the case is tried in capital offense. If the soldier does not elect trial to a military judge, a trial with members will automatically be afforded for the soldier. The right to trial by the court may refuse Article 15 punishment demanded the trial by the courts martial. U.S. Code of Military Justice non-judicial punishment. On the provision of the U.S. Code of Military Justice, Article 15, commanding the officers may impose non-judicial punishment upon the soldiers who commit minor offenses within their unit. The purpose of the non-judicial punishment is to train, correct, and reform. It also promotes and behavior changes in the soldier without stigma of the U.S. Court martial conviction. If you are accused of the soldier and you have an option either demanding trial, court martial, accepting non-judicial punishment, once you and the commanding officer have been passed the judgment sentenced to you and punishment awarded to you unjust and disappropriated the offense, you may appeal to them part of the sentence next higher to appeal all or part of your sentence to the next higher authority. The appeal authority may set aside, decrease, suspend, and let stand any portion of the entire original sentence. However, the authority cannot in any way increase the original sentence. Article 15 of the U.S. Code Military Justice for the form of non-judicial punishment increased by the commanding officer for relatively minor offenses. The Article 15 cannot be exposed to a soldier who demands a court-martial. The two types of the Article 15 proceedings summarized and formal. Summarized proceedings may be used of very minor misconduct. The punishment should not be exceeded or reprimanded extra duty restriction for 14 days or any other combination of the punishment. The formal proceeding begin with the initial notification ending the perils of the punishment. Maximum punishment of a soldier grade E4 below the field grade commander include a reprimanded extra duty of 45 days, restriction of 60-day correctional custody for 30 days, loss of 1/2 of the pay for the per month for 2 months, grade reduction of one or more lower grades, or a combination of these punishments. 3.3 the U.S. Code Military Justice Court-Martial. There are three types of court-martial: summary, special, and general. The trial courts are the military equivalent trials of the judge juries. Their differentiate among the three based on their composition, level of authority, severity of punishment. The summary of court-martial. The court-martial composed of the commissionary officer of the active duty within the grade of the captain. Above the purpose of summary court-martials to make through impartial measures as minor offenses to make sure that the justice is done in the interest both in the government and the accused being in the safeguard. Only the enlisted personnel may be tried for some court-martials. Anyone in the subject summary court-martials may refuse to be tried in summary court-martial. Whether the offense is minor depends on several factors, including the nature of circumstances of offenses. Also consider the age, day, grade, duty, assignment, record, experience of the accused. The maximum punishment that can be given in the summary of the court-martials is soldier pay, the E grade for 4 or below. Confinement of the hard labor for 1 month, for forfeit of 2/3 of the month of the payments for 1 month. Reduction of the lowest enlisted grade. Special court-martial. The court-martial consists of the military judge, not less than 3 panels, and when required, it is held that the relatively serious offense is the maximum punishment that can be given by a special court-martial is the confinement of the hard labor for 6 months. Forfeiture of 2/3 of the month's payment for 6 months. Reduction of lowest entitlement. Some special court-martials empowered of the rule of the bad conduct discharge. The punitive discharge deprives the soldier of many veteran benefits. General court-martial. The court-martial consists of military judges, not less than 5 panels. Members may be required. It is held by the serious offense of the general courtmanship may impose the authorized punishment, including the death penalty in certain cases. 3.4 U.S. Code Military Justice Punitive Articles. The following list contains a descriptive title, general provisions selected by punitive articles of the U.S. Code Military Justice commonly occurring for the training environment. Article 83, the fraudulent enlistment, appointment, and separation article can apply to the soldier. Procedures on enlistment of the armed forces knowingly false, representing deliberately concealment and qualifications and enlistment of the appointment and receive pay and allowance of their unders. Proceed to own, separate the armed forces, knowingly false represent, deliberately conceal the eligibility of separation shall be punished by the court-martial and directly. Article 86, absence of leave. Article punishment of the court-martial can be made direction and apply. May direct any can employ and apply to any soldier without authority fails to go to his appointed place of duty at the time prescribed to. The absent of himself remains from his organization place of duty required to be a certain time. Article 89, disrespect toward a superior commission officer. Article punishment of the court-martial direction apply to the soldier who behaves with disrespect toward the superior commission. Respective behavior that detracts from the respective authorities, superior command officers of the NCO. Disrespect behavior includes the following actions: language, abusive epithets, or other contemptuous denunciation or language. Neglecting a customary salute, showing marked disdain, indifference, insolence, impertinence, unfamiliarity, other rudeness in presence of superior. Article 90, assaulting, willfully disobeying superior command officers. The article in punishment of the court-martials may direct any applied to the soldier who 1. Strikes a superior commander, officer, or draws a lift of a weapon over the silence while he is in the execution of his office, willfully obeys the law, willfully disobeys the law, and lawfully commands his supervisor, commander, officer, if offense committed in the time of war, so since death and could not be administered. If the offense is committed when not in war, punishment other by the death of could be restrained. Could be result. That is assaulting willfully and disobeying a superior. Could cost you the death penalty. Article 91, insubordinate conduct or warrant officer, NCO, or petty officer. Article is punishment of the courts martial may directly can apply the soldier who strikes, assaults, warrant officer, the non-commissioned officer, petty officer, while this officer's execution in the office willfully obeys the lawful order of the warrant officer, non-commissioned officer, or petty officer, treats the commitment, treats with contempt, disrespectful language, deportment toward the warranted officer, NCPO officer, while the officer's execution of his office. Article 92, failure to obey orders. Article, any punishment court-martial may direct and it can apply to the soldier who 1. Violates or fails to obey the lawful general orders or regulations. 2. Display a lawful order issued to a member of the armed forces. 3. Directly in performance and duties shall be punished as a court-martial may direct. Article 107, false official statements. Any person subject to the chapter who intent deceives, assigns, and false records, return regulation order, or other official documents, knowing that it defaults, making other false statements, knowing that it is false, shall be punished. A court-martial may be direct. Official statements, including all statements may be in the line of duty. Article 115, malingering. Article, punishment of the court-martial may direct a soldier who has the purpose of avoiding work, duty, or service, foreign, illness, physical disability, mental lapse, or deterrent, intently inflict self-injuries. Article 121, larceny, wrong appropriations. Article, any punishment the court-martial may direct apply any soldiers who wrongfully obtain the withhold means for the possession of the owner and the person any money, personal, the article value of any kind. The verdict of larceny will result in the theft of permitted, deprived, defraud another person of the use, benefit of the property appropriate of his own use, and use any other purpose other than their own owner. A verdict of wrong appropriation will result in using an item taken when interpreted and deprived of defraud another person of the use of benefit property the appropriate of his own use or other use of a person of the owners. Article 128, assault. Articles, punishment of the court-martial directly can apply to the soldier who attempts to offer the unlawful force of the violence to bodily harm to another person, whether or not to attempt the officer consummated. Offers consummated. Commits the assault with a dangerous weapon other than means of force alike to provide whose deadly or grievous bodily harm. A verdict of aggravated assault will result in an assault committed by the intention of inflicting grievous bodily harm without a weapon. Article 134, general article. Article applies all disorder, neglects of the prejudices of good order, displeasure of armed forces, all conducts, nature of the bring discredit upon the armed forces. Crimes of offenses not capable, which subject crimes and not offenses not capital, which person subject to the chapter may be guilty shall be taken or cognizance of by a general, special, or special court or summary of court-martial soldiers. A violation shall be punished according to the nature and degree of the offense. 3.5. The following forms of the punishment may be imposed: the violation of U.S. Code and military justice. All forms of punishment used in the restriction of the U.S. Code and military adjustment. The U.S. Code and military adjustment provides limitation sentences based on the following factors: the nature of the crime, the form, the injunction, not judicial punishment of the court-martial, the position, grade, and the individual assigned for the punishment, the type of the court-martial convicted of the soldier reprimanded, the conveying authority of the court-martial commanding officers, the punishment of the censure soldier order to concur with the condemned the wrong, a reprimand is served for the form of censure the adverse reflects upon the contact of the person addressed. The court-martial shall not specifically term or warning down a reprimand. The reprimand of the prosecutor should be issued in writing or conveying authority reprimanded a judge. Court-martial is punitive censure. A forfeiture pay and allowance deprives the individual individual accused of all specific amounts of money to accrue earned in the future as a result of the service armed forces in the U.S. unless torture future is acknowledgement and since the future shall state the exact money of the be forfeited each month in whole dollars, the number of the months forfeited futures will last. Fines make the accused immediately and the liable use of the entire amount of the money specified in the state, and then so fine may only be adjudged by a court-martial, may be adjudged instead of only addition forfeiture. However, the fine normally only is a sentence case whether the accused unjustly or enriched as a result of convicted offense. Reduction of pay grade, except for the provided by the RCM 1301D, the court-martial may sentence an enlisted member to reduce the lowest of the intermediate pay grade. Restriction of specified limits describes the accused normal, their liberty and privileges. The sentences will specify the physical geographical locations in which the individual is located, individual allowed, how long the restriction shall last, the individual must present in the specific location. Hard labor without confinement and perform additional other regular duties do not excuse, relieve, or personnel from performing regular duties. Ordinarily, the immediate commander may be accused designate the amount of character of labor and perform confinement. The place of confinement shall not be designated by the court-martial. The court-martial shall not be adjudged by sentence of the solitary confinement to the confinement without hard labor. The authority executing sentence of confinement may be the hard labor, whether or not the law words of hard labor are included in the sentence. The punitive separation of a court-martial may be adjudged with the administrative support and the services. These are three types of the punitive separation. Dismissal applies one of the court commissioned officers, commissioned warrant officer, cadets, or midshipmen may be a judgment only to the general court-martial, regardless of the maximum punishment specified for an expensive Part 4 manual of the court-martial's dismissal of the judgment of an offense of which the commissioned officer, commissioned warrant officer, cadet, or midshipman have been found guilty. Dishonorable discharge applies only to enlisted person warrant officers who are not commissioned may be adjudged only to general court-martial. Dishonorable discharge should be reserved for the separated relations for the dishonor following the conviction of the offensive regardless of civil jurisdiction as felonies of offensive military nature requiring severe punishment. Bad conduct discharge applied to only the enlisted person made in judgment. General court-martial, special martial has been a requirement of the RCM 201 FUB. The bad conduct discharge is served as dishonorable discharge and designed as a punishment bad conduct rather than punishment for the serious offense other than civil military nature. It is an appropriate accused for the being convicted repeatedly of minor offenses whose punitive separation appears to be necessary. Death, number 9. 3.6 Army Equal Opportunity Policy. The Equal Opportunity Policy ensures that the Army-wide concentrated effort maximizes human and potential entire for the fair treatment of all personnel based solely on merit, fitness, capability, and support of readiness. The EO faces the physical justice, equity. The Army Equal Opportunity emphasizes fair, equal treatment and provides the equal opportunity treatment for the military personnel, civilian employees with regard with race, color, religion, gender, or national origin. This policy applies to in, on, off posts, and applies on and off posts, extends to soldiers, civilian employees, the family members, and includes the working, living, and recreational environments. The Equal Opportunity Complaints Processing System addresses the grievances alleged of unlawful discrimination, unfair treatment on the basis of race or national origin, color, gender, race, national origin, color, gender, religious affiliation, sexual harassment. Attempts shall be also made to solve the problem at the lowest possible level within an organization. If complaints admitted, it will be investigated. Personnel found in the violation of the Equal Opportunity Policy are subject to the punishment of the U.S. Code of Military Justice. The EEO complaint process, individual encouraged to attempt the resolution complaints to confirm information alleged or offered to offender by the informing the appropriate officials above the offensive behavior and the unfair treatment. Individual responsible to advise the chain of command on specific of any discrimination of sexual harassment as appropriate of the action to be taken. Personnel must be submitted by the legitimate complaints and should be exercised caution about frivolous and reckless and alleged allegations. The Army has two types. EO's complaints. EO complaints, informal and formal. Informal complaint is an informal complaint is a complainant that is a soldier, family member of the DA, civilian, does not wish to file in writing. Informal complaints may be resolved in complaint directly. The assistant of another unit member, a commander, and another person in the complaint chain of command. Typically, this issue is to be taken carefully and can be resolved through the discussion and problem identification, clarification of the issue, and informal combat is not the subject of suspense nor is reportable. A formal complaint is formal complaint is one of the soldier's family member of the DA civilian's files when writing and swears in the accuracy of the information of the DA Form 7279R equal opportunity complaint form they obtained by the unit of the higher headquarters level. The formal complaints require specific action or subject timelines, the required documentation, actions, and taken. Alternate agencies. Although handling EO through the chain of command is strongly encouraged, this is not the only channel a soldier can feel uncomfortably filing a complaint. The chain of command should complain with against a member of the chain of the command. Therefore, a number of the alternative agencies within the complaint can be made. The following agencies are frequently used: the EO, the Equal Opportunity Advisor, Chaplain, Provost, Marshal, Staff Judge, Advocate, Housing Referral Office, Inspector General, and the Equal Opportunity Hotline. Right to appeal if the complainant receives the investigation fall to the reveal the facts of if the action in the behalf of the received is insufficient, he or she has the right to appeal the next higher command. The complaint may not be appealed taken against the private perpetrator as if any was taken. 3.7 Military whistleblower detections. DA personnel prohibited taking the acts of the reprisal against soldiers from preparing, and protecting communication. Protected communication is the lawful communication member of the Congress, inspected by the general, and the member of the DoD, audited, inspection, investigation, law enforcement organization, any other person or organized designated to receive each such communication regarding the information the soldier responsibly believes evidence violation, regulation, prohibition, sexual harassment, unlawful discrimination, gross management, the gross waste of funds and other resources, abuse of authority, substance, and specific danger of the public health or safety, reprisal of the threat, taking threat of unfavorable personnel, withholding the threat, withholding the favorable personnel, and action reprisal against soldier from preparing and protecting communication. The chain of the command will ensure the complaints are protected by reprisal and retaliation for the filing equal opportunity complaints should the shoulder to be threatened in such an act with should act and the reprisal occurred in the most important circumstance of the DOG-IG. 3.8 The Army policy of relationship between soldiers. The Army historically related on the custom, tradition, bounds, and acceptable personnel responsibilities between the soldiers. Different rank soldiers relationships have been judged on the reference to the custom and the traditions of the service. The relationship between the service of the soldiers and the different of the mark. Different relationship between soldiers and different rank are prohibited if the compromises to appear. The compromise integrity and supervised authority of the chain of the command. Casual attack of the perceived partial unfairness involved air period and involved in the improper greater of the position of the personal gain aware are perceived to exploit their coercive in nature create actual or clear predictable adverse impact, discipline, authority, morale, mission accomplished. Fraternities improper relationship. The Army fraternities policy prohibits certain categories personal relationships between others enlisted personnel regardless of their service. Personnel policy applies to the different gender relationships, same gender relations, violation of fraternization, improper fraternity relationship may be punished by Article 92 U.S. Code Military Justice, violation of law, general regulations. 2. Categories of prohibition of relationship between the officers and enlisted personnel, including ongoing business. The prohibition does not apply to the landlord-tenant relationship such as the sales of automobile. The house does not apply to the borrowing, lending of money, commercial solicitation, any other type of ongoing financial business relationship, dating, and shared living accommodations other than the direct operational requirements, intimate sexual relationship, gambling, other prohibited relationships. A. The personnel relationship between permanent party members of the initial entry soldiers. Any relationship between permanent party personnel and initial entry soldiers and not required in the transmission is prohibited. This includes but is not limited to the following: drinking, dancing, gambling, writing or receiving personal letters, riding in a permanent privately owned car, having sexually conversation, contact, kissing, blowing, caressing, fondling, hand-holding, or intercourse. The prohibition against the relationship between the permanent party personnel and the IET soldiers apply to the permanent personnel without regard to the installation assignment of the personnel party member in the training. Personal relationship between the recruiter and the recruits, and the relationship between permanent party personnel assigned to the attached to the U.S. Army Recruiting Command and the potential prospects. Personal relationship between recruiters and recruits. Any relationship between permanent personnel assigned to the attached U.S. Army Recruiting potential prospects, application member to delayed entry program, delayed training program are not required by recruiting mission is prohibited. Romantic relationship between initial entry training soldiers. Illegal association initial entry training soldiers involving in any actual attemptual consensual contact soliciting between among the soldiers who are basic combat training or advanced into initial training. Soldiers are therefore expected to avoid the following association acts: consensual contact socializing between among soldiers of the basic combat track and adult advance in initial training, which involves hand-holding, embracing, caressing, kissing, touching, massaging, fondling a sexual nature, engaging sexual intercourse, sodomy, the use of sexual, explicit, suggestive, abstinence language gestures directed towards with the respect of another soldier, the basic combat training, or the advanced initial training. The general based on the race-based harassment, disparaging language and actions by the soldier, group of the soldier, the basic combat training, and advanced initial training directed towards the soldier of the group and the soldier of the basic combat training, or an advanced initial training, entry into the living quarters, latrines, or other designated for other exclusive use of soldiers for the opposite set, unless regarded or required by training mission official duties of the health or safety emergencies. Languages or socializing the non-sexual, non-harassment nature of the basic combat training and advanced initial training of the soldier is not eligible interaction based on the spirit and enthusiasm generated by the basic transmission of the professional development associated with the basic combat training and advanced initial training. And finally, there is no prohibition by the initial entry training soldiers may be the soldier of the opposite sex talking to one. There is no prohibition from the initial entry soldier of the same or opposite sex talking to one another, developing friendships. Army Sexual Harassment Policy. The policy U.S. Army sexual harassment, inappropriate and unacceptable conduct. The sexual harassment destroys teamwork, detrimental to combat readiness. The Army is an organization but people that success be based on the ability to perform the environmental mutual dignity of the fair treatment. The categories of sexual harassment are as include verbal, telling jokes, nonverbal, blowing kisses, physical contact, for example, touching, blowing, or blocking a doorway. Individuals who believe in being sexually harassed are responsible to help resolve issue. One of accomplishing this is confront the harasser, telling him or her that the behavior is not appropriate, it is not welcome, or must stop. Another way of resolving sexual harassment is to file an informal or formal complaint. Intimidation, harassment, retaliation against the filing a complaint is not prohibited. D. Sexual harassment is the form of gender discrimination, involves unwelcome sexual advancements, requests for sexual favors, other verbal, physical contact, sexual natures. The following conditions indicator of sexual harassment: when a submission or rejection of such conduct is much of the condition of the person's job, the pay, or the career, such as when a submission of the rejection of each conduct is used as the basis career employment decision affecting the personnel, when such of it creates an immediate hostile offensive working environment, unreasonable interference interferes with the individual working performance. Any person in the supervisor command position who condones any person of the sexual behavior and the control, the influence and effect of the career, pay, or job of the military member of the civilian employee engaging in the sexual harassment. Any soldier civilian who makes a deliberate, repeated, unwelcome verbal comments, suggestion, and physical contact with sexual nature engaged in sexual harassment. G. The uncomfortable because of the certain sexual remarks, behavior that you should be assertive. If responding to behavior that is over then becomes sexual harassment, you shall be turned away. You shall be tell the person how to describe how you feel. Describe what you do not like. Stay the focus of the behavior, the impact. Clearly state what you want in the future. Tell any potential offender, I do not want to hear that again. Don't touch me again. If the harassment continues after you are warned, the harasser, their words, action go to the immediately supervisor unless the person doing the harassing, in the case of the supervisor, appropriate is not taken. You want to give up the chain of command at the post of the equal opportunity advisor. Sexual harassment is one of the forms of discrimination, gender discrimination based on race, religion, color, national origin, or also is also against the law. Determining and conducting the fall of the category sexual harassment considers the following questions: is the behavior sexual in nature? Is the behavior unwelcome? The behavior created in the hostile offensive working environment that has the sexual have been demanded, requested, suggested, special condition, employed the career, job, successful, suggest individual actions deal with sexual harassment, included confront the harasser, file a complaint, use an intermediate spokesperson, write a letter to the harasser about the behavior and expected resolution, report a harassment to the chain of command. 310. Appropriate behavior. The appropriate behavior described as good as soldier expected to behave. You are a soldier 24 hours a day, should always be honorably. You have the respect of the units and fighting the men and the women who have been given their lives in the fighting in America. Explain the inappropriate behavior between the alcohol, drug, and abuse and intolerance. All soldiers, you can help prevent and improve inappropriate behavior by promoting behavior that is based on Army values, leadership in Chapter 2, tolerance to the differences from us, to the ethical decision making, adherence to the code of conduct, and you can also prevent the appropriate behavior by demonstrating the respect of others and others in respect of yourselves. Alcohol and drug abuse. Your success in the Army is dependent upon the good soldier of on and off duty. You are obligated to obtain the illegal drug use and avoid abuse of precipitation over-the-counter medication. Make a responsible decision about alcohol use, and if you choose to abuse the substance, you will make subject to administrative judicial action. Use the alcohol use and the abuse of the alcohol consistent with the Army values. Substance user maintains the standard performance, discipline, and readiness necessary to accomplish the Army mission. Such soldiers identify the absent abusers of alcohol, other drugs entered in the sub-abuse system program, ASAP rehabilitation. The ASAP Army Substance Abuse Program is commanded by Program Commander, will direct or detect and program problem soldiers. If he or she feels that the potential continued military service soldier failing to respond to rehabilitative efforts who are deemed unfit for other military service will charge self-referral and non-discernible identifying alcohol, other drug abuse. If your work of the performance, conduct, and relationship, other health becomes impaired because of the abuse of alcohol or other drugs, you have the personal obligation to see. You can ask for help in the chain of the command as the Army Substance Abuse Program or the chaplain. Most soldiers will refer to the treatment will not have the previous drug or alcohol violations used against them in judicial action. 312. The consideration of others. Diversity and positive effects in military service. Consideration of others defined as those the actions indicate sensitivity in regard to the feelings and needs of others and awareness of the impact of one's behavior, being supportive of one of affair and with the others. Objective consideration of other programs and fosters the strength of command and climate, reinforcing the importance of the trust, teamwork, and dignity with respect to others.